Well, thank you very much, Mark, for that big build-up. It wouldn't have been cricket. It might have been rugby.
I think it was rugby.
Yeah. Okay.
After.
That's all right. Yeah. Good. Well, I'm here to talk about family law, but I always feel a terrible fraud talking about family law these days. It's 19 years since I was in the Family Division of the High Court, and nearly 15 years since I was in the Court of Appeal. The House of Lords and UK Supreme Court get very few family law cases. Those that we do get are usually about child abduction and other international aspects of child law. Very few about mainstream family law, although we have had a spate recently, of which more anon. So I have only a limited picture of what goes on in England and Wales, let alone in the rest of the UK and the common law world. The future of family law is a big subject. When I was a family lawyer, I thought that I did have a view of the bigger picture, of where family law had been, where it now was, and how it might progress. It went something like this. Traditionally, family law was all about the patriarchy, keeping the family's property and power together, increasing it if possible, making suitable alliances, providing reliable heirs through whom that property and power could descend in the patrilineal line. Lifelong marriage was the vehicle for achieving this. The husband was in charge, traditionally in law, through the common law doctrine of the unity of husband and wife and the strong presumption of the legitimacy of any children born to the wife, with a correspondingly strong obligation of wifely fidelity, at least until the heir and the spare had been provided. After that, she could play away to her heart's content. Marriage settlements could achieve some independence for wives from wealthier families, not through sharing the husband's property, but by giving them some separate property of their own. And all of this was, of course, largely irrelevant to the lives of the lower orders. When the doctrine of unity was abandoned, late 19th century, bit of the 20th century, all wives could theoretically develop separate lives and property of their own. However, in practice, the husband retained control through the traditional distribution of roles between breadwinner and homemaker. Power was still firmly located in the breadwinner, supported by the doctrines of separate property and fault-based divorce. A wife had no claim on her husband's property unless he gave her a share or she bought into it. A wife who is judged to blame for the breakdown of the marriage might lose her home, her income, and her children. A husband who was judged to blame could keep his property, most of his income, and a fatherly relationship with his children. And all of this was seen as protecting the sanctity of marriage. But it all changed with statutory reforms which mostly came into force in England and Wales in 1971, and their interpretation by the courts in the decades which followed. Conduct-based divorce was still on the statute book, but this had little or no impact on the practical arrangements for the children, the home, and the finances. The property of both parties could be shared out in whatever way the court thought fair. There was no presumption in favour of equal division. In practice, priority was given to preserving a home for the children. The less advantaged spouse often got the larger share. Income provision for the less advantaged spouse remained available if necessary, although everyone preferred a clean break, if it could be achieved. Conduct during the marriage rarely affected the financial settlement. The arrangements for the children depended on their best interests. Again, conduct during the marriage rarely affected that. So much so that the courts were slow to recognise that domestic abuse of a parent was also damaging to the children, but eventually we did. It was assumed that both parents should retain a parental relationship with their children. So the emphasis of the law shifted from protecting and preserving the marriage for its own sake to protecting the interests of the children and the financially disadvantaged spouse if the marriage broke down. The law provided for flexible solutions tailor-made to the circumstances of the individual family. The family was its own little social security system, even after the breakdown, which also protected the interests of the state so far as it could. And increasingly people began to ask, if this was the object of the law, why should it be limited to the legally married? Discrimination against the children of unmarried parents obviously couldn't be justified. But what about discrimination between married and unmarried adults? And between same-sex and opposite-sex couples? Their needs are the same. Hence, as long ago as 1979, the Scottish Law Commissioner Eric Clive could suggest that marriage was an unnecessary legal institution, albeit with a question mark. I must say I made a similar observation at the same conference where Eric Clive said that. I got loads of stick years later from the Daily Mail, and Eric Clive has never had a scintilla of criticism. I don't know why it is that a bushy white beard turns you into an authoritative guru, whereas a different chromosome complexion somehow doesn't. There we go. Anyway, the Supreme Court of the United Kingdom has just had an interesting illustration of the non-discrimination theme in the case of Steinfeld and the Secretary of State for International Development. One of the funnier things about that case was that the respondent Secretary of State changed at each of the level of court at which the case was. I think it started with education, and then it went on somewhere else, and it ended up with international development. And that was all because the minister in charge was not one in charge of family law, but one in charge of equalities. Anyway, what was the case about? Like New Zealand, the United Kingdom legislated for civil partnerships for same-sex couples in 2004. And Great Britain, but not Northern Ireland, legislated for gay marriage in 2013. Unlike New Zealand, the United Kingdom has never legislated for civil partnerships between opposite-sex couples. Rebecca Steinfeld and Charles Kyden are in a long-term committed relationship, but they hold genuine conscientious objections to the institution of marriage, regarding it, in their counsel's words, as, I never thought I'd hear these words in the Supreme Court of the United Kingdom, quote, heteronormative and patriarchal. I could just feel my colleagues thinking, what does that mean? Anyway, you all know what it means. From a lawyer's point of view, it is very difficult to understand the objection to marriage these days. Marriage has not been patriarchal since the 1970s and cannot be regarded as heteronormative since the introduction of gay marriage. But people's views about the nature of institutions do not necessarily depend upon the law or even upon cold reason. After all, we don't get married or form relationships for cold reason, do we? They're much more complicated than that. The couple's many supporters are ample evidence of strong feelings against marriage, just as the movement for gay marriage was evidence of strong feelings in favour of it. The couple brought judicial review proceedings complaining that to deny them the same choice that gay couples have between marriage and civil partnership is unjustified discrimination in the enjoyment of the right to respect for their private and family life, protected by Article 14, read with Article 8 of the European Convention on Human Rights. They failed at first instance. The judge held that their complaint did not even fall within the ambit of the right to respect for private and family life. Okay, that sounds a bit peculiar, doesn't it? You might have thought how you structure your legal relationship with one another in relation to your private and family life did fall within the ambit of Article 8, but she managed to hold that it didn't. This view was not shared by the Court of Appeal and was not persisted in by the government when the case got to us. The judge also held that, even if it did fall within the ambit of Article 8, the discrimination was justified by the government's desire to wait and see what effect the introduction of choice had on gay couples' demand for civil partnership before deciding how to eliminate the discrimination. Yes, it is laughable, isn't it? Yeah. Sorry, I shouldn't say things like that, should I? That's not sufficiently respectful. And two members of the Court of Appeal agreed with this, that it was justified. The Supreme Court unanimously disagreed, denying opposite-sex couples a choice which was allowed for same-sex couples was obviously unjustified. It was our job to say so by making a declaration under Section 4 of the Human Rights Act that the relevant provisions of the Civil Partnership Act restricting it to same-sex couples were incompatible with the Convention rights. Such a declaration under our Human Rights Act leaves the law unchanged, but sends a clear message to government and parliament that the court considers that the UK is in breach of its international obligations under the Human Rights Convention. It's then for government and parliament to decide what, if anything, to do about it. The problem with discrimination is that there is often a choice between levelling up making civil partnership available to everybody, or levelling down, abolishing civil partnership. Of course, there's another choice. They could abolish marriage as well, but I don't think that's going to happen. There's no doubt that the simplest solution is to make civil partnership available to everybody. That would cause no problems at all, easy to amend the Act, and not to have to worry about what you do about all those civil partnerships that are already in existence. It's rather difficult to understand why the government is so reluctant to adopt it. Earlier this year, the then responsible Secretary of State declared her support for a private member's bill opening up civil partnerships to opposite-sex couples. But then there was a reshuffle, and responsibility shifted, as I've said, not only from one Secretary of State to another, but from one department to another. And the private member was persuaded to accept an amendment which would simply call upon the government to do some research. The plan they put to us, which was published 2 days before the hearing, would not have led to legislation to correct the inequality which they themselves had created until well into the 2020s. So, but at least we are talking about discrimination and equality. It's encouraging evidence that there are still many couples who wish to enter into a formal legal status, bringing with it rights and responsibilities towards one another as well as towards their children. But while that is going on, there are forces at work which could endanger the role of marriage, civil partnership and family relationships as their own little social security system, protecting and safeguarding the welfare of all their members. And much of this is happening in the name of equality, which is a powerfully attractive goal to many of us. But it calls in question what we mean by equality. Classically, equality means treating like cases alike. But it also means not treating unlike cases alike, and not adopting rules or practices which put one particular group at a disadvantage when compared with another. So what are those forces which, in my view, are endangering the goal of equality in family law? Late last year, the Times newspaper, you probably know the Times purports to be an upmarket newspaper, of serious complexion, and in many ways it still is. And it still regards itself as the paper of record in my country. And they launched a 5-point plan for the reform of family law, with the aim, as they put it, to bolster family stability, end financial injustice, and remove acrimony from divorce. Now, 2 of the reforms for which it is campaigning could have the potential to strengthen family responsibility, if not necessarily family stability. First, extending civil partnerships to opposite-sex couples, because, of course, this would encourage more people to enter into binding legal commitments to one another. But, of course, it would depend upon what those commitments were. And secondly, providing financial remedies for unmarried cohabiting couples, as is already the case in Scotland and, of course, here. Again, it would depend upon what those remedies were, because they would almost certainly not be as good as those within marriage. And if those within marriage are reduced, well, then what would happen to those between unmarried couples? The third proposal is, to my mind, either neutral on the central philosophical issue or likely to strengthen family relationships. And this is reform of the ground for divorce, so as to get rid of the conduct-based reasons for finding that a marriage has irretrievably broken down. But, of course, this, again, would depend upon what replaces them. It's very boring, but currently the sole ground for divorce in England and Wales and Northern Ireland is that the marriage has irretrievably broken down. But this can only be shown by proving one of 5 facts: that the respondent has committed adultery and the petitioner finds it subjectively intolerable to live with him, that the respondent has behaved in such a way that it is not reasonable, objectively, to expect the respondent to live with him, 2 years desertion, which nobody ever bothers with, 2 years separation if the respondent consents, and 5 years separation if he or she does not. Scotland also has adultery in behaviour, but the separation periods are 1 and 2 years respectively, and separation is much more frequently used there. South of the border, more than half of divorces are based on adultery or behaviour, but a very much smaller percentage north of the border. Now, those of you who sensibly abandoned conduct-based divorce long ago may be entertained by our recent case in the Supreme Court of Owens and Owens. Mrs. Owens is now 68, and Mr. Owens is 80. They married in 1978, 50 years ago now. They've 2 grown-up children. They built a successful business and have significant assets. The wife left in February 2015 and petitioned for divorce on the ground of the husband's behaviour in May that year. The petition contained the usual brief, anodyne particulars of the husband's behaviour, because most people don't defend, and most judges simply tick the box and say that's good enough. The respondents are advised to suck it up, no matter how unfair it seems, because defending won't save the marriage. Petitioners therefore try to be as gentle as possible if they're properly legally advised. This husband filed an answer, so fuller particulars were given. Their tenor was of a loveless marriage in which the husband was bullying and hypercritical of the wife, disparaging her in front of others. The facts were hardly in dispute. The case was listed for a comparatively short hearing because everybody expected that it would settle on or before the day. But it didn't. So the judge is faced with having to cope with this long list of particulars of this and that in a much shorter time than a proper hearing of it would take. So he only heard evidence about a few incidents. And most unusually, he held that the marriage had irretrievably broken down, but that the husband had not behaved in such a way that the wife could not reasonably be expected to live with him. It's a good illustration of everything that is wrong with our current law. The marriage had irretrievably broken down, but they cannot be divorced until they have been separated for 5 years. Actually, you will have worked out that that's not very long now, but there we go. Usually these cases are undefended, and the threshold of behaviour required is very low. There's no need to show that the respondent is to blame for the breakdown of the marriage, or indeed that his conduct is the cause of the breakdown. The Act doesn't require that. But it gives the impression that he is to blame, and that he's being publicly blamed. The public don't understand the true position. This is evidenced by a current storyline in our long-running radio soap opera, The Archers, An Everyday Story of Country Folk. Any of you have heard of The Archers, or even heard The Archers? It's wonderful in the way it deals with family law. It's terrific education in family law. But at the moment, there is a couple who are separating, and the wife is adamant that the marriage is irretrievably broken down. And they're arguing about who should be the petitioner, because they all think that the petitioner will publicly be the innocent one and the respondent will publicly be the guilty one. And they all seem to be saying it. I hope somebody's going to come along and tell them they're wrong, but because they were very good on the domestic abuse side a year or two ago. Anyway, as you can imagine, this causes all sorts of resentment and bitterness. If people hated one another for the sorts of reasons that Mark was talking about the other day, they hate one another even more if they have to detail those things in a divorce petition. If undefended, of course, it allows for a very quick divorce, a matter of weeks. But the practical consequences in money, property, children have to be sorted out later. And relying on conduct can make it more difficult to do this amicably. And of course, conflict is damaging for children. You don't need me to tell you all this, because you adopted a more sensible approach to dissolution long ago. Is there any reason to believe that family life is any less stable and family responsibility taken any less seriously in New Zealand as a result? No. I would doubt it very much indeed. Perhaps there'll be some empirical comparative study which could tell us the answer. But of course the question is, what should replace it? The Times is campaigning for separation, 1 year with consent and 2 years without. In practice, the Scottish solution. You have 2 years separation. But there is a crucial difference, as I understand it, and you'll tell me if I'm wrong. You can sort out the property arrangements before the divorce. So that makes it much easier for the parties to separate and then simply wait. Our problem is that property and fine arts cannot be sorted out until after the decree nisi. Added to that, the remedies which we designed in the Law Commission, in part, to enable the court to decide who should live in the matrimonial home in the short term before a divorce have been weakened by the court's insistence that it is, this wonderful word, draconian, temporarily to evict a person who is entitled to occupy. This means that the most vulnerable women, especially those who are victims of domestic abuse, of the sort which deprives them of all sense of their own agency and autonomy, will find it the hardest to separate, especially if they have children, no money, and nowhere else to go. So a much better solution was proposed by the Law Commission back in 1990 in its report on the ground for divorce. Day one or both parties formally declare that they believe that their marriage has irretrievably broken down. Day 365, one, not necessarily the same one, or both, declare that it has. And then your marriage is dissolved. In between, the property, finances and arrangements for the children can be sorted out, although doing so would not be a condition of getting a divorce, because that would encourage blackmail and similarly unfair pressure. The Family Law Act 1996 enacted a much more complex version of this scheme, which was generally thought unworkable and so was never brought into force and has now been repealed. But a recent large-scale and serious study by Liz Trinder and her colleagues not only confirms all the things we thought wrong with the law all those years ago, but also adopts our solution, with the waiting period reduced to 6 months. Miraculously, on Saturday, our government has just published a consultation paper proposing just this. This is something which would have been unthinkable 20 years ago. But it would obviously make the dream of universal online divorce decrees much easier to achieve. Sorry, it's a brilliant consultation paper. I think it's wonderful, so I shouldn't be cynical about it, should I? Yeah. Anyway, so that's where we are with divorce law. Two other elements in the Times campaign are very different. One is ending the outdated and patronising meal ticket for life that can result from present laws on splitting assets and awarding maintenance after divorce, except where hardship would be caused. They could have added, as in Scotland, but they didn't. Now, this is a radical attack on our flexible approach to tailor-made solutions. As other countries such as Canada have recognised, the equal sharing of assets on divorce is certainly an advance on the law as it was beforehand, when everything depended upon who owned the assets, and it was usually the husband. But it is not enough to give each party a genuinely equal outcome. Sometimes the imbalance can be corrected by an unequal distribution of the assets, giving each party the clean break which most people want. Sometimes it can't. And in that case, the gap can be made up by periodical payments. And we have an illustration in another recent Supreme Court case. You see, we're getting all these family law cases. I don't know where they came from. Anyway, this was Mills and Mills. The husband and wife married in 1987. They're both now aged 52. They have one child. The wife is a beauty therapist, and the husband has a surveying business in 2 companies, originally owned by husband and wife in equal shares. The husband left in 2000. There was a consent order on divorce in 2002. The wife transferred her shares in the business to the husband and got the lion's share of the proceeds of sale of the former matrimonial home. She got 230,000 odd versus his 23,000 odd. She had ill health because of gynecological problems, which may well have played a part in the breakdown of the marriage, but we don't know that. And this impaired her earning capacity at the time. So this was made up by an open-ended order for periodical payments of £13,200 per annum, not index-linked. She then entered into a series of property transactions, buying ever more expensive homes with ever larger mortgages on the rising market. Everybody was doing this in England until 2008, because everybody assumed that the price of property was going to keep going up, and so a bigger and bigger mortgage would always be okay because it could always be repaid out of the sale price of the house. Well, you all know what happened with that. By 2015, she had no capital. It was not entirely clear where it had all gone, and she was living in rented property. The husband applied to buy off her periodical payments for roughly 2 years' purchase. The wife applied for an increase, as there was a shortfall of some £4,000 between the order, together with her earnings, and her budget, which was described by the judge as very modest. Well, if you tot it up, she had some earning capacity, plus £4,000, plus the £13,000. Not necessarily the most modest of budgets, but possibly the judge described it as such because he thought it was. Anyway, he countenanced the shortfall because the husband should not have to pay twice for the wife's accommodation needs when it was the wife's own decisions which had led to her current predicament. It was the rent that was the problem. But he couldn't predict how long she would need the periodical payments, so he refused both applications. The Court of Appeal gave the wife permission to appeal and increased the periodical payments to make up the shortfall. The Supreme Court restored the judge's order. The case was billed in the press as an all-out attack on the so-called meal ticket for life, when it was actually no such thing, because the husband had not been given permission to appeal against the refusal to bring the periodical payments to an end. And we're not allowed to hear appeals from the Court of Appeal against things which the Court of Appeal hasn't given permission to appeal to them. It's in our statute. We can't do it. So this whole idea that it was going to be an all-out attack on the meal ticket for life was wrong. But in any event, Lord Wilson, who gave the leading judgment, pointed out that it was an inaccurate term, given the range of circumstances in which periodical payments can be brought to an end. There's no such thing as a meal ticket for life. Now, the Family Justice Council has issued guidance on assessing financial provision after divorce, both for self-represented parties and for courts. The second edition of the Courts Guide came out earlier this year. This says that for most couples, provision for needs takes up most of the assets, leaving little room for the sharing and compensation principles, also suggested as rationales for redistribution by the House of Lords in the famous case of Miller and Miller, Macfarlane and Macfarlane. Incidentally, Mr. Miller, who was divorcing, or being divorced by, matters not which, his second wife, has as his third wife the Mrs. Miller who brought the very famous case about Brexit before the Supreme Court. Yes. And I remember sort of looking out across the crowded courtroom, it was very crowded, and looking to see where Mrs. Miller was, because one could recognise her because of her photos in the press, and thinking, I recognise that man. And he had, of course, been the same man who'd been sitting at the back of the appellate committee room in the House of Lords in the case of Miller and Miller. So it's a small world, isn't it? Anyway, in their guidance for courts, the Family Justice Council quote and endorse the Law Commission that the objective of financial orders made to meet needs should be to enable a transition to independence, to the extent that that is possible, in the light of the choices made within the marriage, the length of the marriage, the marital standard of living, the parties' expectation of a home, and the continued shared responsibilities, importantly childcare. We acknowledge the fact that in a significant number of cases, independence is not possible, usually because of age, but sometimes for other reasons arising from the choices made during the marriage. Note those words, arising from choices made during the marriage. That's both a criterion for giving financial relief and a reason for giving financial relief. In the Council's view, it is generally right and fair that relationship-generated needs should be met by the other party if resources permit. So that is the standard England and Wales view at the moment. An alternative view is that marriage is a partnership which should be dissolved with equal sharing of the assets accumulated during the marriage, but no provision for future needs unless there would otherwise be grave hardship, and then not for very long. This is more or less the law in Scotland, and the divorce, open brackets, financial provision, close brackets, bill, introduced in the House of Lords by Baroness Deach, would introduce something very similar for England and Wales. In her view, the present law perpetuates the indignity of lifelong support, makes the law inaccessible to lay people, obstructs settlements, and entails heavy legal costs. Now, the Scottish law is not at all surprising. There was no history in Scotland of long-term periodical payments, whereas periodical payments were the typical form of provision south of the border. And the highly respected Scottish Law Commissioner, the aforesaid Eric Clive, who is a great friend of mine and I love him dearly, had long held the view that there is something fundamentally repulsive about the whole idea of dependent women. Of course, it should not be assumed that the highest aspiration for a woman is to become dependent upon a man. It used to be so assumed, but it should not be assumed. But we can't ignore the fact that marriage is a partnership in which the spouses often play different roles, and often varying over time, for their mutual benefit and that of their children and other members of the family, such as their elderly parents. Daughters-in-law, for example, do amazing things for their aging parents-in-law, don't they? I'm just watching my sister's daughter-in-law, who is doing amazing things for my sister, who is seriously ill. And the sense of obligation that daughters-in-law have to their parents-in-law is something to be treasured and rewarded. It doesn't necessarily depend on gender, of course, but in practice it usually does. The most common family pattern in England is a full-time working father and a part-time working mother. I don't know whether it's the same in New Zealand, but it's very common with us. Women often incur a motherhood penalty in terms of lower earnings and pension entitlements. The impact of divorce is on average considerably worse for wives than for husbands, whose incomes on average increased following divorce. Someone who gives up work, even for a few years, in order to concentrate on childcare or other family responsibilities will never make up what they have lost. That's an Institute for Fiscal Studies study earlier this year. And there are lots of other research studies to the same effect. Despite all that, the reality is, as research by Emma Hitchens and Joe Miles has shown, that there is no meal ticket for life. Clean break culture is prevalent. Periodical payments for spouses are largely confined to cases involving dependent children, and variations between courts may be more a product of local wealth levels and housing costs than differences in interpretation of the law. In their view, rather than being undignified or reflective of or reinforcing a victim mentality, orders that acknowledge the economic impact of how a couple have chosen or have been required by circumstance to raise their children protects the dignity of the primary carer, more fairly distributing between the parties the full economic impacts, positive and negative, of their marital partnership. So that's one debate that's going on. And secondly, the Times is also campaigning to give prenuptial agreements the force of statute. Well, if you've read my dissent in a case called Radmacher and Granatino, you will know that I have reservations about pre-separation agreements, whether made before or during the marriage. Although they may produce clarity and certainty, the object is almost always to provide for less than the receiving party would otherwise be entitled to expect. Nor can the vicissitudes of family life be reliably foreseen. The Law Commission has proposed that, to be binding, the person wishing to enforce such an agreement would have to show that certain obvious procedural safeguards have been complied with, and that such agreements could not contract out of provision for need. Baroness Deitch's bill does not contain that exception, not surprisingly because she doesn't believe in provision for marriage-generated need, and it puts the burden of proving that the safeguards have not been complied with on the person wishing to avoid the agreement. The point I'm trying to make is that both of these proposals seem to be rowing back from a vision of a family law which seeks to achieve substantive equality between differing spousal roles. They're moving towards a formal equality of treatment, which in practice is much more favourable to one role than to the other. The same may be said of certain developments in family court processes, which have had a profound impact on access to justice in the family court in England and Wales, and I understand that something very similar has been happening in New Zealand. The Legal Aid, Sentencing and Punishment of Offenders Act 2012, universally known as LASPO, was part of the Ministry of Justice's Herculean response to the coalition government's austerity agenda. I think the Ministry of Justice agreed to more cuts, or more severe cuts, than almost any other government department. No doubt, the ever-expanding demand for publicly funded legal services needed to be cut back. But the method chosen was to exclude whole areas of legal activity, not only from legal aid for representation in court, but also from any sort of legal advice or help. And amongst the excluded areas was most of private family law, cases involving husbands and wives, mothers and fathers. At the same time, public funding continued to be available, not generous, but available, for family mediation. The view was that settling cases out of court was a good thing, which indeed it is, and that mediation was somehow a better, and certainly a cheaper way of doing that, than negotiation through solicitors. A lot of people don't understand that traditionally the way in which most family cases are resolved is by negotiation through solicitors. Solicitors don't take cases to court unless they have to, and they only have to if they can't do a deal with the other side, and they're much better placed to do a deal with the other side than are the parties themselves, with or without the help of a mediator. People don't seem to understand that. So public funding is no longer available for solicitors to do that. It is available for them to provide help with family mediation. This consists of a fixed fee for advice provided in support of mediation, and another fixed fee for drafting a consent order if settlement is reached, irrespective of the type or complexity of the case. This is much less than half what a solicitor could get for assisting with a divorce petition and helping to achieve a settlement, even under the previous far from generous fixed fee regime. The take-up of help with family mediation has been alarmingly low. One unintended consequence of the withdrawal of public funding for family legal work was an immediate and drastic reduction in referrals for mediation. Who do you suppose refers cases to mediation? The lawyers do. And if people couldn't go to lawyers anymore, well, then they didn't get the referrals. So they're not being referred to mediation. Many of the not-for-profit mediation services, which were members of National Family Mediation, have had to close, including the iconic Bristol Family Mediation Service, where it all began. And the lawyer mediators are not doing any better, as far as I know. However, after LASPO withdrew public funding and all of that happened, the Children and Families Act 2014 introduced a requirement for most people who want to begin private law proceedings about children or financial remedies first to attend a Mediation Information and Assessment Meeting, a MIAM. Doesn't sound right, does it? The court can refuse to issue the application unless they do. The other party is expected to attend, but can't be forced to do so. The most the court can do is adjourn the proceedings for non-court dispute resolution to be attempted. Many respondents would be only too happy for such further delay to take place. A MIAM is a short meeting with an authorised family mediator to provide the parties with information about mediation and for the mediator to assess whether mediation is appropriate. But neither party can be forced to mediate if they don't want to. That is a cardinal principle of mediation. There are some exceptions to that, but I won't bore you with them. Now, all of this promotion of out-of-court ADR is in addition to the ADR provided for in the court's own rules. Most applications for financial remedies are referred to a judge for a financial dispute resolution appointment, which is a meeting held for the purpose of discussion and negotiation, with a judge who will not be the judge if the case has to fight. Most applications for private law orders relating to children must go through a first hearing dispute resolution appointment, at which the judge, working with the CAFCAS officer, will seek to assist the parties in conciliation and in resolution of all or any of the issues between them about the children. CAFCAS stands for Children and Family Court Advisory and Support Service. This is a public body whose principal function is to provide reports for the court in cases involving children. The premise of both non-court and in-court dispute resolution processes is that solutions agreed between the parties to family proceedings are better and more long-lasting than solutions imposed upon them by the courts. In children cases, it also helps to establish lines of communication between parents who will have to continue to cooperate in the parenting of their children as they grow up. In both children and financial cases, it enables parties to fashion solutions which may not be amongst those which the court could devise. The independent family mediation providers fought a long battle to establish the advantages of non-court mediation over in-court dispute resolution, which they sometimes referred to as banging heads, no doubt unfairly. Now we have both. But whatever the validity of the premise, I tend to think that agreed solutions are better than solutions imposed by the courts. This emphasis on agreed solutions brings particular problems, especially with the reduction in public funding for legal advice and help. Traditionally, non-court mediators are impartial. They can offer legal information to the parties, but they cannot offer legal advice. They can facilitate an agreement, but they cannot turn that agreement into a court order if one is needed. Mediators themselves feel that mediation works better if both parties have access to legal advice. Without some form of legal benchmarking, neither party will have any sense of what they should be seeking, nor what they are, in principle, broadly speaking, entitled to. This is particularly so in financial disputes, where disclosure is vital. An imbalance in basic financial knowledge is likely, and the financial relationship and management of money will have to change dramatically in the future. Yet how far can a mediator, however financially and legally literate, go in making up for the lack of partisan legal advice? And how far can the judge, who approves any consent order, be expected to check it for fairness? They cannot be expected to weed out all unfair orders, nor can the judge give legal advice if they do spot something wrong. So family mediators, at least in my country, have traditionally adopted a facilitative rather than an evaluative approach. But if more and more clients are coming without the benefit of legal advice and help, they may be pushed into adopting a more evaluative approach. Lawyer mediators may be more comfortable with this than non-lawyers. And at the same time, the Solicitors Regulation Authority has changed the rules so that solicitors can now accept joint instructions to draft a consent order. Clients may well welcome this, but it raises difficult issues for the lawyer, who perceives that the proposed order is not in the best interests of one of his clients. What's he or she to do? In short, unless very carefully handled, with proper access to in-court dispute resolution if mediation fails, all this emphasis on non-court solutions is likely to place yet more power in the hands of the financially more advantaged party. In other words, to work against rather than in favour of substantive equality. The other consequence of the legal aid cuts is that more and more family litigants are coming to court because they do not each have a lawyer to negotiate for them, and that when they do come to court, more and more of them are representing themselves. This places burdens on the litigants themselves. The government's own literature review before the Act revealed that, as a result of legal aid cuts, the public would face poorer case outcomes, longer delays in the resolution of cases, and lower prospects of settlement. It also places a burden on the courts, with which they're not entirely comfortable. As one High Court judge has put it, while some litigants in person will be intelligent and marshal their cases well, many will be emotional and obsessional about what has happened to them. Yes, you all know that. Many are very nervous, often upset, sometimes very angry. Yes? And it is invariably a real challenge for the judge to be able to get the best out of people who are in that state. And it's hardest of all, of course, to handle a case fairly where one party is represented and the other is not. Now, this again is a development which places more power in the hands of the party who can afford to be legally represented and works against rather than in favour of substantive equality. And it's not as if the procedure in our family courts is simple and straightforward. Is it in yours? I jolly well hope it is, because you're generally so much more sensible than we are. certainly not simple or straightforward, calculated to be user-friendly to self-represented litigants. The rules and practice directions are formidable in themselves before you get to the substantive law which they're there to support. Worse still, an applicant may have to negotiate at least 4 separate sets of court proceedings, as well as the child support regime. Remedies against domestic ill treatment and abuse, and to secure short-term occupation of the family home, under the Family Law Act 1996, the divorce petition itself, which is usually the simplest of the lot, proceedings about the arrangements for the children, under the Children Act 1989, and proceedings for financial remedies under the Matrimonial Causes Act 1973. These are all quite separate processes, each demanding their own application form and supporting evidence. Why, oh why, can we not have a one-stop shop? A single application form on which the applicant can apply for all the remedies he or she seeks, supply the relevant evidence only once, and come before a judge who can deal with it all at once, having first tried all issues mediation to sort it all out. So, some of these difficulties are, I am sure, the law of unintended consequences. Good ideas and necessary reforms do not always produce the beneficial effects contemplated. But the trend to me is a worrying one, away from a genuinely egalitarian vision of the family, in which different and changing roles are equally respected, and in which family members are expected to look after one another, and towards a vision where each family member has to fend for himself or herself if things go wrong, and, if she is sensible, to plan her life on that basis from the outset. I do hope I'm wrong, but I fear that I may not be. So that's the future of family law, folks. Well,